Another update in the Kelsey Fitzsimmons case. So, as you may be aware by now, if you've been following, Kelsey Fitzsimmons was out on bail and she was under house arrest. She had a GPS ankle monitoring device. But part of the restrictions is that she was required to blow into the scram device multiple times during the day to test for her alcohol. Now, this was very difficult for her to do because, after all, she was shot, in case I didn't make that clear yet. So she has broken ribs and all types of other injuries that she's recovering from after spending about 53 days in the hospital. So her attorney, Tim Bradle, filed a motion with the judge to simply modify the restrictions. Let's not make this so torturous for a presumed innocent individual. Let's make this a little bit more easy and allow her to test some other way. We'll do a urine test, do some other alternative ways to test. So that was the motion. And the judge decided that since it's so torturous for Kelsey to use the scram device, well, we'll just lock her up and that will be less torturous for her. Apparently that was the thinking there. Anyway, so Timothy Bradle filed a motion for reconsideration, and then he submitted a supplemental filing with a medical record or a medical note letter from the treating surgeon who treated Kelsey at Mass General Hospital, and showing in that letter what her conditions were, what her injuries were, and that it's very likely that she is still suffering from broken ribs and difficulty breathing into these type of devices. Well, the judge came out with an order yesterday saying, too bad, I'm not reconsidering the motion, and Kelsey can sit in jail. I'll wait for her trial, apparently. Now, let's go through this motion. And as you know, on this channel, I try my hardest not to use profanity. But I got to tell you, this judge is really, really testing me. Also, some parts of this order, quite frankly, reads like a dumped girlfriend. I mean, it's just like she needs a bowl of ice cream immediately. That's what this judge needs, not an opinion in an order on a criminal case. That's not what she needs exactly. So let's go through the motion, and let's go through the order, I should say, and let's see if this makes any sense. All right, here we go. Order on defendant's motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing. The defendant, Kelsey Fitzsimmons, stands indicted for one count of assault with a dangerous weapon, which that may be the most confusing part of this case. Now, I wasn't in the grand jury. I don't know, grand jury proceedings are very locked down and secretive. Nobody knows what goes on in them. And it's very difficult for me to imagine what happened there, because if what we're hearing, that she pointed the gun at Officer Noonan, and that's why Officer Noonan shot her, well, that's attempted murder. That's not assault with a dangerous weapon. So I don't know how they came back with an indictment on assault with a dangerous weapon. So that's a big question for me. Anyway, moving on. Following 3 hearings in 2 weeks, can you believe it? 3 hearings in 2 weeks. My gosh. Will you just leave us alone with your filings? Okay. Following 3 hearings in 2 weeks regarding conditions of release pursuant to that statute 58A2B, the case is now before the court on Fitzsimmons' motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing. As there is nothing in the motion that was not known to Fitzsimmons and her counsel when this matter was last before the court on September 11th, 2025, there has been no change in circumstances or newly discovered information that would warrant revisiting the court's decision pursuant to 58A4. So the judge is saying here, well, you knew about this all before, and therefore pursuant to 58A4, there's no new information. And the statute allows me to revisit rulings regarding bond if there's a change of circumstances or if there's newly discovered information. But you knew all this stuff before, so therefore I can't even change my mind if I wanted to. You're not showing me that there's a change of circumstances. Now, if you look at 58A4, this is where it is, and look at the first part where I highlighted. The hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained if the judge finds that one, information exists that was not known at the time of the hearing, or that there has been a change in circumstances, and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person or the community. So the judge is understanding this part of the statute, that when it says the hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained if the judge finds that information exists that was not known at the time of the hearing. But she's understanding that to mean is that there's information known to the defendant. So if the defendant learns of new information, then that's the reason why we can reopen this. But that's not exactly what this means. Very clearly, what this means is that if there is new information, also that the judge can find out. If there's new information that the judge claimed before she didn't know, and now she does know, then that can also warrant a revisit to this, to the bond. But the judge apparently thinks that this is only talking about the defendant. All right, going back to the motion, to the order. As explained before, Fitzsimmons' failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of this court's efforts to fashion the least restrictive conditions of release that would both allow her to avoid incarceration and reasonably assure the safety of all other persons in the community as required by Section 58A. Thus, the motion is denied. So, you are just trying to manipulate me. That's what you're doing. Doesn't it sound like she needs a bowl of ice cream? I mean, and a chick flick. Like, that's what she needs. And she's just taking it out on Tim Bradel and Kelsey Fitzsimmons. So I don't know what's going on there, but it seems like it's coming out in this hearing, in this order. So remember that this is actually a very important part. The least restrictive conditions, that's actually a requirement. To have least restrictive conditions, I'll show you, because you've got, let's see, is this 58A? I think this is 50 right here. Subject to the least restrictive further condition or combination of conditions that such a judicial officer determines will reasonably assure the appearance of the person, so can't be a flight risk, as required, and the safety of any other person in the community that the person and etc. goes through all these different subsections. So it has to be the least restrictive. And the reason why it has to be least restrictive is because there is a constitutional right here that's implicated. And anytime that you want to take away someone's liberty, you have to use the least restrictive way to do it. So the question that you have to ask yourself is the least restrictive way to ensure the safety, first of all, the appearance of Kelsey. I don't think she's going anywhere. There's no flight risk there. But the safety of any other person, what is the least restrictive way that we can ensure the safety of poor Officer Noonan, who towers over her and is probably 100 pounds over her at least, and the community? You got to be very careful of the community. I mean, look at her rap sheet. I mean, look at her criminal record. Kelsey's got a criminal record up to wazoo, so you got to be very careful. The community has to be very safe from Kelsey, apparently. So the judge feels that, well, this is the least restrictive way is just to lock her up. I mean, that's the only way to ensure the safety of Officer Noonan and the community at large. And that's why she denied it. Now, let's get on to a little bit of our analysis because it really goes off the rails a little bit. So here we go. After the Commonwealth moved to hold Fitzsimmons as dangerous pursuant to 258A, the court concluded following a hearing on August 28th, 2025, that the Commonwealth met its burden as to the dangerousness and that Fitzsimmons' release on personal recognizance alone would not reasonably assure the appearance of the defendant as required or would endanger the safety of another person, poor officer, I think that's what PO stands for, poor Officer Noonan, or the community. Rather than hold Fitzsimmons in custody, the court sought to fashion the least restrictive conditions of release that would reasonably assure her appearance and the safety of all the other persons in the community as required. As we just read for you, it's got to be the least restrictive conditions that would assure her appearance and the safety of all the people involved, including PO Noonan, poor Officer Noonan. Let's move on. Based on the serious nature of the allegations against her, as well as evidence presented by the Commonwealth about Fitzsimmons' history of aggressive behavior while intoxicated, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community and imposed that as a condition of release. The court imposed a number of other conditions, including GPS monitoring, that Fitzsimmons reside with her mother and stepfather at their home under house arrest, and that she have no contact with the victim, any witnesses, or her child. After a further hearing regarding conditions of release on September 8, 2025, Fitzsimmons was released from custody. Now, something you're not going to see in this opinion at all, which I think is very significant, is the fact that Tim Bradel did submit the psych evaluations for Kelsey, where the doctors have opined that she is not a threat of harm to herself or others. But let's kind of ignore that part now because it's not going to be very helpful for this analysis. Let's move on. In the 3 days that followed, Fitzsimmons requested relief from 2 of the conditions of release to which he had just agreed. You just agreed to this, and now you have the audacity to come back to court and ask for those conditions to be released. First, immediately after the September 8th hearing, defense counsel requested that the GPS condition be lifted so that Fitzsimmons could undergo surgery the next day, September 9, 2025. With no evidence to support the contention that Fitzsimmons could not wear a GPS device during surgery, and based on probation's representation that the GPS device does not always need to be removed for surgery, the court denied this request. So the GPS motion was denied. They didn't attach any medical records that show that she has to have it removed. Okay, so they denied that motion. All right, fine. Okay, motion denied. Let's move on. 2 days later, Fitzsimmons filed an emergency motion for immediate relief from scram order, which sought relief from the court order requiring her to breathe into a scram device because Fitzsimmons was unable to do the testing without experiencing severe abdominal pain and dizziness, and because the breathing necessary to the task is impossible in her condition and impairs the healing of her broken ribs and punctured lung. At a hearing on that motion on September 11th, 2025, counsel argued that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by Scram, but presented no alternative testing options to ensure Fitzsimmons remained alcohol-free. Well, that's not true, is it? We listened to the hearing ourselves. We heard the hearing. Thank you, Jess Machado Show, and whoever else posted it. And we were able to hear that actually, Tim Bradel did suggest urine testing at that hearing. So this is just blanketly false. Moving on. Faced with counsel's representations that Fitzsimmons could not comply with the Scram testing, a condition that was critical to the court's decision to release her on conditions, and in lieu of incarceration, the court vacated its prior order of release and ordered Fitzsimmons held without bail pursuant to whatever the 58A. All right, let's move on. It's not that long, so just stay with me for a moment. In the specific context of persons held pursuant to 58A, the hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained if the judge finds that, as we just read this statute, information exists that was not known at the time of the hearing, or that there has been a change in circumstances and that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person of the community. More broadly, Massachusetts Rule of Criminal Procedure 13A5 empowers the judge to reconsider any pretrial motion which has been heard and denied upon a showing of substantial justice. In this case, there is nothing in the motion that was not known to Fitzsimmons when this matter was last before the court on September 11, 2025. And again, this is coming back to her faulty understanding of the statute that it means that there has to be a new circumstances or something new learned by the defendant as opposed to the judge. If the judge didn't know about something and you want to bring to the judge's attention, that's what this statute was created for. So the judge is claiming, this was what the judge was arguing and claiming in her order initially why she locked up Kelsey Fitzsimmons and revoked her bail, was because you didn't submit any medical evidence. So the judge is basically, when she claimed that, oh, you didn't submit any medical evidence, I don't know if you're just making this all up or not. So you, judge, have to be educated. So now that's what Timothy Bradel did in compliance with the statute to say that to the judge, hey, you didn't know about this information before. There's a change of circumstances now. She has a doctor's letter that you asked for. And now this is new information for you, judge. And now that's what this statute was created for. So now that there's new information, we can bring it in front of you, judge, that you didn't know about before. And now that can help you create an alternative to the testing using the Scram device. But for some reason, that analysis is just beyond her. However, Rule 13A5 is not limited to instances where there are allegations of new or additional grounds that could not have been reasonably known when the original motion was filed. Okay. Instead, a judge always has the power to reconsider his or her own decisions during the pendency of a case, yada, yada, yada. Now, part of the reason here, you'll notice also in this opinion, the judge doesn't make any sort of mention to 58B. She sticks with 58A. And you know why? Because 58B is the statute which allows the judge to revoke bond. And in that statute, as we've discussed in previous videos, the statute says that there has to be a violation. There has to be that you violated a law, federal or state, or that you violated one of the conditions of release, which did not happen in this case. No one said that it happened in this case. She blew sometimes, which was incomplete, but eventually she did get it. So it was complete, and the probation officer himself said that he would not consider that a violation. So the judge cannot use 58B, which is why she stays away from it in this entire opinion. She's sticking with 58A and the provision which says that if there's new information, the judge could on its own revisit a ruling. And a judge always can revisit a pretrial ruling, as she's mentioned in this case. So that's why she's using 58A to as a basis for what she's doing here. Ultimately, whether to do so or not is a matter of judicial discretion, and a reviewing court will disturb a judge's decision on a motion only when there has been an abuse of discretion. Fitzsimmons' pending motion asked the court to reconsider its revocation of release and instead impose available alternative alcohol testing by random urine tests as set forth in the attached email provided by probation. That attached email was purportedly sent by Assistant Chief Probation Officer Jeff January at 6:21 p.m. on September 10th, 2025, the day before the hearing on Fitzsimmons' emergency motion for immediate relief from scram order. So we have this email which was purportedly sent by Assistant Chief Probation Officer Jeff January. It's purportedly sent by him. We don't know if it's for sure sent by him. Relief from scram. The email notes that the only alternative to scram testing is urine testing through a vendor called EverHealth, which would require Fitzsimmons to travel to one of the EverHealth sites to submit to a test. The email concludes by offering to provide more specific information on EverHealth tomorrow morning. So that's what the email said, right? That there's this alternative, there's urine testing, you can go to EverHealth. So this is the probation officer talking. He puts this all in an email. Now, we don't know that this was sent by the probation officer. How do we know that this is reliable hearsay? Maybe this is Tim Bradel making this stuff up. Maybe he just created an email account that looks like it's from Jeff January. At the hearing on September 11th, the court gave the parties ample opportunity to present their arguments. Mr. January was present and testified under oath. For some reason, rather than bringing the alternative testing option to the court's attention and inquiring about it with Mr. January during his testimony before the court, defense counsel at that time sought only an order completely relieving Fitzsimmons of the condition of release requiring her to submit to scram monitoring. And again, that is absolutely incorrect. That's not what he said. He said, yes, I need to relieve her from scram so she doesn't have to endure the torture, but he did say we can look for alternative testing. So I don't know what you're talking about. I'm not sure which hearing you were at. We all heard the hearing. He didn't say no scram device, no testing, and finish. That's what I want you to modify your order. That's not what he said. He said she cannot do the scram. There's alternative testings. He must have said the word alternative 10 times in that hearing. And I didn't go back and listen to it. So you can go back and listen to it and let me know in the comments how many times he said alternative testing in the hearing. But the judge has a different memory. The judge is saying, no, for some reason, and again, and she's bringing up the point that for some reason, when the probation officer, Mr. January, took the stand, because he did take the stand, Tim Bradel didn't ask him about the alternative testing. Why didn't you ask him while he was on the stand? I gave you the opportunity. You could have done that. Why would you just rely on an email which was purportedly from him? It was only after the hearing, when the requested relief was denied, that defense counsel brought to the court's attention via the pending motion that Fitzsimmons could be tested for alcohol via urine test performed by EverHealth. Well, he didn't say by EverHealth at the hearing. You're right. You got that part, Judge. Good catch. But he did say urine testing. He heard it. I heard it. He said it. Rather than live testimony under oath from Mr. January on September 11th, defense counsel now asked the court to rely on an unverified email. This email is unverified. This is just unverifiable hearsay. You expect me to rely on this email from Mr. January that is purportedly from him, an unverified way that provides little detail about EverHealth and the testing it offers? The motion also implicitly asked the court to modify the conditions of release, placing Fitzsimmons on house arrest except for medical court and attorney visits with 48 hours notice to probation, as urine testing would reportedly require her to go to an EverHealth facility with less than 48 hours notice. So that's true, right? We would have to modify the other orders. So you're implicitly asking me to modify the other house arrest order. Yeah, you got it, Judge. Good job. Good pickup. So what's the problem? Is that too difficult also? Is that just asking too much? You want me to modify 2 orders? You want me to go back and change 2 orders now? That's too much for me. First, you're filing these 3 motions in 2 weeks, having 3 hearings in 2 weeks. Who's ever heard of such a crazy thing? And now you want me to modify 2 of my orders? My gosh. What do you think this is? Court? What do you think this is? A criminal defendant who has a presumption of innocence? What do you think this is? Now look at the footnotes here. You know how much I love footnotes. So here we go. After hearing argument from the parties and testimony from Mr. January, the court asked defense counsel if he had anything else to submit. In response, he sought to admit into evidence a September 8th, 2025 email from Mr. January reporting his observations of Ms. Fitzsimmons during the scram installation, but not the September 10th, 2025 email from Mr. January or live testimony from him about alternative testing. So you did submit one email, which says that Mr. January had observed that Kelsey has trouble breathing into this machine, but you didn't submit at the time the September 10th, 2025 email. Now they saw it. Now the judge saw it in this unverified purported email from Mr. January. We have no idea who it's from really, but he was on the stand. Could have asked him these questions. Before taking a recess to reach a decision, the court once again asked defense counsel if he had anything else to submit, and he responded in the negative. And now she cites the recording, FTR recording beginning at 12:27 p.m. Oh, that's what you got to focus on, not the other parts of the recording where he asked for alternative testing. Shortly thereafter, defense counsel vaguely suggested, it was too vague. You got to be direct with me. You got to be direct. You can't just vaguely dump me like that. Vaguely suggested that there might be other alternatives that might involve Fitzsimmons leaving the house for urine testing, but never provided the court with the information contained in Mr. January's September 10th email or any other specific information regarding an alternative testing option that would allow the court to assess whether such an alternative option was appropriate in Ms. Fitzsimmons' case. So yeah, you mentioned urine testing, but you didn't give me all the details. You got to give me all the details before, how am I supposed to know about any of this? Your later submissions, that's how I'm supposed to know about this? Give me a break. You suggested alternatives, but you have to give me exactly the roadmap, every single detail, who's going to take her, what time is going to be taken, how long it's going to take, how much urine is going to come out, what she's going to feel like afterwards, what type of pain medication she's going to take after on the way back to what she's going to eat for lunch that day so it's not going to affect. Give me a break. My gosh. But I'm just reading this. I'm just reading this legal analysis from one of the judges there in Massachusetts. Let's go to the next footnote. The court declined to consider September 8th, 2025 email from Mr. January's evidence at the September 11th hearing on grounds that it was hearsay. And Mr. January was at the hearing and available to provide live testimony under oath. While Section 58A provides that the rules concerning the admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, that's exactly what it says. And it does say specifically that hearsay is admissible. It does say that. So she realized she's got to do something about this. For otherwise inadmissible evidence to be admitted at Section 58 hearing, it must be reliable. And there must be good cause for the decision not to present live testimony. You ever heard of form over substance? And this is like the perfect example. Technically, you should have done it this way as opposed to that way. Who cares? We have a criminal. You know what's going on here, Judge? Let's go. Come on. Stop playing these games. Like that's, you have to have the right margins. When you file these things, you have to have the right margins, and the footnotes should be single spaced, not double spaced. And there just happens to be that there's too many words on this footnote according to the rules. You can only allow only a certain amount of footnotes per page. Let's stop it already. Just stop it. Okay, have your ice cream and calm down. Good cause can be shown in two ways: by presenting a valid reason for not presenting a live witness, or by showing that the proffered evidence bears substantial indicia of reliability and substantially trustworthy. So trying to back up the reason why she did not allow it, she gave it no weight, 0 weight. By the way, she said that she gives that 0 weight before the probation officer took the stand. Before she even knew that he was taking the stand, she said she gives that email 0 weight. So that was before, Judge. That was before he took the stand, when you said in open court that you give it no weight. Well, let's move on. The court points out that when it initially outlined conditions of release at the August 28th hearing, the court specifically noted in the context of considering whether it was necessary to require random drug testing, the importance of minimizing the number of times Fitzsimmons was allowed to leave the residence. We had a hearing about this, and the judge is saying that I said I have to be very careful about Fitzsimmons leaving the house. After all, just because she was shot, and she probably doesn't have the strength to hurt anybody, but still we have to be very careful with this very dangerous person who's 5'3" and 110 pounds. Got to be very careful. Officer Noonan is shaking in his boots. He's under the covers. So we have to minimize how many times she leaves her house. And this is what came up by the drug testing. After being advised by probation that Fitzsimmons would have to leave the house for drug testing, and because it was alcohol and not drugs that were of concern in Fitzsimmons' case, the court declined to impose drug testing and imposed only alcohol testing via scram device because it could be done from the confines of her home. So this was the reason that the judge is saying that I did not require her to do drug testing, because I didn't want her to leave the house because she's such a danger to the community. I didn't want her to leave, and that's why we said, okay, we're not going to do drug testing, and we're going to do alcohol testing, but it has to be from the confines of her house. The court continues to recognize the importance of minimizing the number of times Fitzsimmons is excused from house arrest for the sake of assuring the safety of the community. We must assure the safety of the community from Kelsey Fitzsimmons. The court also notes that Fitzsimmons has had other opportunities to raise the issue of her inability to comply with scram testing and suggest alternatives. So now the court's saying, yeah, and you know what else? You could have done this before. Why did you wait to break up with me 3 weeks later when you knew you were going to break up with me 3 weeks before? Is that nice? Is that nice of you to do that to me? You could have done this earlier. The court first advised Fitzsimmons that her release was conditioned on being alcohol-free and subject to scram testing at the initial Section 58 hearing on August 28, 2025. So we said that she's going to be subject to scram on August 28, 2025. Oh, by the way, she didn't try to do the scram device quite yet on August 28, 2025. How are you supposed to know how difficult it's going to be? Let's just ignore that part for now. At the hearing, counsel asked questions and sought clarification about other conditions, but not about the scram testing condition. So you didn't ask about this on August 28, 2025, when I imposed that condition, even though it's very difficult for you to know what it's going to feel like unless she actually tries it, which she wasn't able to do at August 28, 2025, right? All right. In addition, on September 8, 2025, Fitzsimmons submitted to the court a medical notice, which the court impounded upon her request. Without revealing sensitive information, that pleading represents that Fitzsimmons has trouble breathing due to injury sustained from a gunshot wound. So September 8th, when there was some sort of medical notice. There was something that was filed that we don't know was impounded that says something about how Fitzsimmons has trouble breathing. Despite this, Fitzsimmons raised no concerns at the September 8th hearing about her injuries interfering with her ability to comply with scram testing. So you didn't mention anything at September 8th. Why did you wait so long? So long. Why did you wait from September 8th all the way to September 11th? I want to know. Why did you wait? I mean, that's an obscene amount of time to wait to bring up this issue again, because maybe you forgot to bring it up in the September 8th hearing. It's just ridiculous. You just sit on your hands for 3 full days before bringing this issue up in front of the court. So you had ample opportunity to bring this up in front of the court. How dare you wait so long? In sum, there has been no change in circumstances or newly discovered information that would warrant revisiting the court's decision pursuant to 58A4. Now, even though, as you see that footnote there, number 3, so just quickly go down to the footnote, the court acknowledged receipt of defendant's supplemental exhibit filing on her pending reconsideration motion, filed with the court on September 15, 2025. It does not alter the court's decision. That is the medical record. That's the medical record that the judge was so intent on getting. So that medical record, which the judge said she had no medical evidence, she had no medical evidence about this at all. And but the fact that you showed it to me yesterday, September 5th, the fact that I just learned about this medical record because I claimed ignorance, that I had no idea about how it's hard for her to breathe into this machine. I had no idea. And now that you submitted it to me, that doesn't change anything. Why should that change anything? You knew about that. I know, Judge, but you pretended that you didn't know about it. So therefore, and you want to just take judicial notice about it, and that no one's contesting in this case that she was shot and that she has all these injuries, but you don't want to take our word for it. So that's why I submitted it to you. So now for you, it should be new information, right? But no, there has been no change in circumstances or newly discovered information that would warrant revisiting the court's decision pursuant to 58A4. Nor has there been a showing that substantial justice requires it. Ordering Fitzsimmons to remain alcohol-free and monitoring for her alcohol use with a scram device was critical to the court's decision to release her on conditions and in lieu of incarceration. Fitzsimmons has had multiple opportunities to advocate for conditions of release with which she could comply and which would satisfy the court's concerns regarding the safety of the community. You had multiple opportunities. You had so many opportunities to advocate. And the fact that you waited so long, I'm not going to satisfy your desires now. Next time, ask for it earlier. Fitzsimmons has had multiple opportunities to advocate for conditions of release with which she can comply and which would satisfy the court's concerns regarding the safety of the community, as evidenced by the dialogue that has taken place between Fitzsimmons, the court, and the probation over the course of the 2 weeks prior to the September 11th hearing. Her failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings. It wasn't just three hearings. They were lengthy hearings. And I've got a lot of stuff to do. So if you're going to tie me up in court with your 3 lengthy hearings, you better say everything that you need to say and not forget anything. Despite 3 lengthy hearings is a manipulation. She feels manipulated of this court's efforts to fashion the least restrictive conditions of release that would both allow her to avoid incarceration and reasonably assure the safety of all of the persons in the community as required by Section 58A. And therefore, she's denying the motion. Now, was there any analysis here about possible other restrictive means? That, I would argue, is required. If you're going to incarcerate someone and take away their liberty after they're already out on bond, I would argue that it's a constitutional requirement for you, in your opinion, to go through other restrictive means, other less restrictive means, and show how each of the means are not going to get the result of keeping everybody in the community safe. And she didn't do that. All she said is that we can't have Fitzsimmons out of the house. We just can't do it. We can have her going to test with her parents, driving her there, and only being allowed out of the house for a half hour at a time. We can't do that. Because in that half hour, who knows what can happen? Who knows what type of havoc Kelsey Fitzsimmons can wreak in that half hour when we let her go to do the urine testing. Maybe there's also a way to do urine testing from home. Maybe she can do the urine testing from home and have somebody pick it up. Can we do that? Can the parents take it over to the lab? Or we're not sure that it's going to be from her, so you need to actually have her there. That's possible. But just analyze this. That's what you have to do in the opinion. When you're taking away someone's liberty, I would argue that as a constitutional basis, that's what you have to do. So therefore, because of the danger that Kelsey Fitzsimmons, it's just too dangerous. It's too dangerous to release her to the public right now. I mean, Officer Noonan, who knows what type of anxiety and depression he's going through right now, just thinking about Kelsey Fitzsimmons showing up at his house one day. Who even knows? And the community has to be safe from her because she has a long rap sheet of criminal conduct that she has done against the community. So we have to really protect everybody and lock her up. So again, this is a very difficult decision to go through, a very difficult opinion, very difficult case at this point. And again, I'm not talking about to the merits of the case at all. She may be as guilty as sin, but she has the presumption of innocence as it relates to this hearing right now. She hasn't been found guilty. And yes, there's probable cause that she assaulted someone with a dangerous weapon. We know how low that burden is. Okay, we should understand she's a criminal defendant. We're not talking about the merits of the case. There's nothing to do with that. This just has to do with whether this was the correct decision to lock her up and revoke her bond, which from everything that I can see and reviewed and researched, it was just plainly wrong. And I don't know, it just seems like this judge has a chip on her shoulder. I don't know what's going on, but this reads like she's offended, like she's offended by something. Something was offensive to her, and not a great place that you would want your client to be in when you have this judge presiding over your case. So we're going to continue to follow it, see if any updates are happening. I think there's an October 7th hearing, so mark your calendars for that. And we'll see you next time. So if you haven't yet, please subscribe and like, and we will see you next time.